Gentlemen, at this time, I would like to ask all in the council chambers to turn off their cell phones, or at least set them to vibrate. Today is May 2nd, 2017, and the public hearing of the Stratford Zoning Board of Appeals will come to order to hear those petitions advertised for this session. For those of you who are not familiar with our process, each petitioner or the designated representative will present their case to the board. When they have concluded, board members will then have an opportunity to ask any questions they may have. I will then ask if there's anybody who wishes to speak in favor or in opposition to the petition. We will ask all petitioners to speak clearly and directly into the mic. After all the petitions have been heard, then we will recess to our administrative session. Interested parties are welcome to stay. However, the board members and staff will only be allowed to speak. Okay. Please be advised that clapping or shouting as a way of expressing an opinion on applications will not be allowed or tolerated. Okay. Thank you very much. Okay, petition number 1. Ms. Young?
Would you like me to read it in the record? Because I think we've opened this previously. Lot 700, Margarita Lawn, petition of Artemio Alvarez seeking waivers of the minimum lot width to create a new building lot for a single-family dwelling in an RS4 district. Hardship, pre-existing non-conforming lot and structure that predates zoning.
Thank you. Is the petitioner here? We'd like to come forward. I already did. Oh, you got anything else to add?
Mr. Chairman, before I start, can someone explain to me procedurally what we're going to do tonight? Because I just want to be ready.
I guess we're going to hear your petition all over again. There was some paperwork, I believe, that Ms. Young, or some clarification from the town attorney on something.
Well, it's my understanding that I presented, all those in favor spoke or didn't speak, all those in opposition spoke, and I rebutted. And we're here now to try and clear up the two questions that were raised regarding merger and your ability to hear a second application. Are we all on the same page with that?
I believe so.
But the public hearing is still open, so I don't think necessarily you're limited.
Well, again, for the record, Robert Rosati for the applicant. I'm an attorney at 3241 Main Street, but I presented and I adopt my presentation from last month. I'm not going to bore you and say it all over again.
It's in the record.
As far as I'm concerned, I'm here to rebut. I think that's the only thing that's left, and I'm ready to do that.
Mr. Chairman?
Yes.
If I may, Mary Young, I thought it prudent for the attorney to be available to respond after the board members had a chance to review the supplemental information that he provided last time we met. So for his sake as well as ours, we collectively agreed to keep this hearing open so we continue a dialogue if necessary.
Okay.
Well, then I'll continue to try and clear up those questions that I think the town attorney has in his memo and Mr. Bansky has in his additional comments. So if that's what you want to do, I do have some further comments and some further documents, and I will proceed if you guys want to listen. Is that what you're thinking, Ms. Young?
Certainly, if you'd like to submit more information, we're here to receive it.
Well, the two big issues were merger and whether you guys can hear this a second time after the denial 10 years ago. And regarding merger, I think I made it clear last time but I'll just repeat it. We have no merger regulation, and I want everybody to be reminded of that. So I think that leaves us with that someone has to look at the clear intent of the owner for a long period of time, whether these two lots, 700 and next door, were ever merged. And I think it's clear from the record that there is no clear intent to merge the properties. As I said before, there's no combined tax bill, no combined legal description, no combined recorded map, no restriction placed on this lot, no construction of the dwelling on the dividing line. It's still two distinct lots, lot 69, 699 and 700. In this situation, the case law is clear. I do have something that I'd like to hand out. I have 5 copies of an excerpt from Robert Fuller's Connecticut Practice Series, Land Use, Law, and Practice, that I'd like to submit. I've highlighted language from section 53.6.
Excuse me, do you have any extras for Mr. Hibansky or Mr. Florek?
Can you? Actually, I need one back to read, and then I can see it. I'd just like to read from Robert Fuller. And this summarizes the current status of the case law regarding merger. Merger may occur as a result of the physical acts of the property owner which show intent to abandon the separate status of two nonconforming lots, such as building a house over the dividing line between the two lots or using the two lots together as one. However, the physical merger can unreasonably be pushed too far, since a property owner may well intend to preserve the separate status of an adjacent lot next to a developed one for financial reasons and investment purposes, but still clear or maintain it so as not to detract aesthetically or economically from the developed lots. The court should be wary of decisions of local zoning authorities who generally want to restrict development, who are influenced by merger claims from neighboring property owners who do not want land around them to be developed. In short, intent to abandon and physically merge lots should be clear. And this is a situation such as in Stratford, where there is no merger regulation. It's been held that where lots were shown on a recorded subdivision map, there was no merger because no re-subdivision map was ever filed, and that was supported by other evidence that the lot was never abandoned as a pre-existing non-conforming lot. That's the case we have here. And again, the finding of merger may be shown by the owner's conduct constructing a house over the property line. The house is not constructed over the property line. There may have been a small encroachment of the garage that's no longer exists, but the house does not straddle a dividing line like other houses in lordship. And that's the current state of what the case law says regarding merger in Connecticut. So, in this situation, the owner could clear the separate lot, use the separate lot, grow a garden, maintain a lawn, but that's not in clear intent to merge or abandon the pre-existing non-conforming lot. And again, I went into that last time we were here. There's no merger here. There's no merger regulation. and you can't consider any neighborhood opposition to fine merger. It's not appropriate for you to consider that. And again, I don't think there's anyone here who can tell us what the intent of the deceased owners were for many years. And without that clear intent, there just is no merger. The second issue is whether you guys have the ability to hear the second application. And it's our position that, of course, you can. It's my feeling that it's absolute nonsense that you can't hear this application. It's been done all the time before this board. It's your opportunity to fix a wrong decision in the past. Attorney Proto, I'm afraid, may have misled you guys or conveniently left off the second prong of the two-part test of hearing a second application. The town attorney and zoning administrator have pointed out that there is a second prong to that test and basically say you do have the ability to hear this appeal. If you look at the town attorney memo, he tells you that the Laurel Beach case upheld the BZA approval on a second application where one was previously denied, and cited the fact that the second application contained additional information that was not presented in the first application. That's the case here. Mr. Urbanski agrees in his new memo and tells you there are new materials and changes to this application, and you can hear it. Again, going back to Robert Fuller, I have a handout.
How many?
I'm going to give you 5 more. Well, I do have some more of those.
Maybe 24?
Again, from Fuller in section 9.6, he basically summarizes the Laurel case and other cases regarding this issue. It appears that there was a similar prior variance application that was denied. I'm sorry, if it appears that there was a similar prior variance application which was denied for the same property, the Zoning Board of Appeals cannot properly grant a second variance application. That's where Attorney Proto stopped. But it goes on to say the test to be applied is whether new or additional facts appear showing a change of conditions or other considerations materially affecting the merits intervening since the former decision. Where there is a successive application for the same property, the first inquiry for the court is whether the two applications seek essentially the same relief, which the Zoning Board of Appeals determines in the first instance, and if they are similar, then the second question is whether there have been a change of conditions or other considerations that have intervened which materially affect the merits of the matter decided. The board can reverse a prior decision if there's been a material change of circumstances or other considerations have intervened affecting the merits and no vested rights have arisen. That's the summary from Fuller. Now, I stated last month the list of the additional information not presented 10 years ago and the new and additional facts that show a change of conditions or other considerations which will allow you to hear this and to reverse what happened 10 years ago. But let me do it again. The original Lordship Manor maps and the deeds from 1914 that I submitted showing the original 50 by 150-foot lots with the restriction of one dwelling for every 50 by 150-foot lot, they were not submitted the last time 10 years ago. That's a new fact and additional information showing other considerations for you to decide upon and reverse the prior decision. The fact that 2 applications 10 years ago were presented asking for a total of 4 variances, where now it is 1 application asking for 1 variance, is a huge change of conditions and facts affecting the merits of this application, and it allows you to hear this and reverse the prior denial. And again, remember, that prior denial ended there. There was no court case. There was no appeal. It ended there. So please, everybody, understand that. I have copies of the survey from the prior application 10 years ago that I'd like to submit. And I've highlighted the wrong or insufficient information on that survey. The building coverage in the grid, the zoning grid, said 20%. It was 25% then, it's 25% now. The data, and I've circled it on that zoning grid, all of it's left blank for the proposed dwelling. That was 10 years ago. So it was impossible for that board 10 years ago to make an informed decision what the application and the material that was before it. Now you look at our map that was submitted. I went through a lengthy process of revising that map with the surveyor. It was updated, and it includes all the proper information. It corrected the mistakes. It listed all the proper zoning grid information, and we presented it properly. That's a huge, huge fact and circumstance. That's new information, which allows you to hear this and reverse the prior denial. Looking at that survey, there's another change to it. That survey doesn't show the garage next door to be removed or the encroaching driveway to be removed. We show both of those on our map, and that alleviates a density issue that was in the record back 10 years ago and a title issue. Those are all new facts and conditions would affect the merits of this application, and it allows you to hear this application and reverse the prior denial. I also have copies of the house plans from 10 years ago. It's a different plan from the house plan we submitted. It shows living space on the side of 150 Margarita and a huge 2-car detached garage in the back. We show a smaller attached garage, and we represent it as a condition to have to reverse that garage and put it on the 150 Margarita side and have no living space on that side and only be use the 10-foot setback, not the 5-foot setback that we would have a right to use. Again, a change of facts and conditions from 10 years ago that allows you to hear this matter and reverse that denial. The prior application did not offer any conditions as a courtesy to the neighbor at 150 Margarita Lawn, and we offered those conditions, and we are submitting them in writing as Mrs. Young requested. We will locate the garage with the 10-foot side yard setback on the 150 Margarita Lawn side. We will have no windows on the side of the house facing 150 Margarita Lawn, and will provide landscaping along the common boundary between lot 700 and 150 Margarita Lawn. Again, new conditions, new facts and considerations that allow you to hear this and grant this variance. So it makes no sense that you can't hear this second application. Again, it's done all the time. You're allowed to hear it. We have proven our hardship. There is no merger. This needs to be granted. It would be an abuse of your discretion if you illegally are swayed by any neighborhood opposition when you legally can grant this variance because we have already shown the hardship. And I think all the lawyers and all the administrators, and I think the board knows this. I know Attorney Knott knows this. I know Attorney Proto knows that this is a hardship and this variance should be granted. And Attorney Proto is going to come before you with similar variance applications like this. And he's going to be making the same argument that I'm going to be making tonight proving to you the hardship. And this board and the attorneys in this town need to be consistent and need to do what's they're legally obligated to do to protect the individual interests of the homeowner, and we're also protecting the town of Stratford. It's going to be an asset, like I said, to the neighborhood, and I'm finished.
Thank Ms. Young.
While you're still at the podium, may I ask you a couple of follow-up questions?
All right.
Thank you. You mentioned the memorandum from Jay Hibansky that he revised on April 17th.
Yes.
You referenced the town attorney's memo dated April 21st. I didn't hear reference to the March 29th memo from the neighbor at 98 Margarita Lawn. If you referenced it last time, could you tell me what your response is to the comment made by Tom Connor at 98 Margarita Lawn, Tom O'Connor?
He wasn't here last time, and he's not here now. Can I see the memo that you're speaking about? Well, first of all, it says it's not being subdivided into 2 building lots. It's a variance request, so that's inaccurate, and I respond that way. It's not a zone change, so he's inaccurate there. I think I've already explained why we have a right to be heard a second time. It's a variance request, and we fit the 2-prong test. And what he thinks Mr. Alvarez knew is irrelevant, and it's hearsay. So that's my response.
One more question, if I may. You spent time last meeting as well as tonight going through the 2-prong test, for which I, for one, am grateful. Thank you. So if we were to agree with your assessment, that then leaves us with what is the hardship, because we've exhausted perhaps the question of we are entitled to be reviewing this application. So I know you did it before, but could you, for my sake, do it again? Identify for the record what is the hardship?
I belabored that, and you guys, if I started again, you guys should tell me to shut up. The hardship is the enactment of the zoning regulations that came along after these lots were created in about 1914 by the recording of that Lordship Manor map that laid out close to 1,050 by 150-foot lots. So it's a pre-existing, non-conforming lot that predates zoning. The enactment of the zoning regs came along and created the hardship. I've said that about 1,000 times in my 30 years into the record.
Thank you.
Any more questions?
Anything, Mr. Dempsey?
No, I'm set.
You're all set?
Yeah,
Good.
thank you. Okay, Mr. Proto.
Good evening, Mr. Chairman, ladies and gentlemen. For the record, Benjamin Proto on behalf of the neighbors at 150 Margarita Lawn. You can end this discussion now because Mr. Rosati has admitted the lots were merged. He just admitted it to you. When he said the small encroachment of the garage and the small encroachment of the driveway. He crossed the line. Those items crossed the line. Removing them does not get rid of the merger. The intent was to use that property for the garage. The intent was to use that property for the driveway. The intent of the deceased owner, who we can't divine his intent from, all we have to do is look at what he did. Put a driveway on that property, put a garage on that property. He intended to use this as one piece, whether it's an inch, a yard, or the entire length. He used that property to serve 699, lot 699. Mr. Rosati's ended your discussion for you by admitting the merger. But moving on, when we were here last time, I spent a lot of time talking about the second prong of the Laurel decision. There is no change of circumstance. There is no change of conditions. Let's start with it's the same exact lot. It's the same exact requested variance, the frontage. The zoning regulations are exactly the same. Oh, and by the way, since we were here long after 1914, that map that he referred to existed, and this commission knew about it. That hasn't changed. The conditions and circumstances that you need to consider haven't changed. So much so, and if I may, Mr. Chairman, these are the minutes of the April 3rd, 2007 Board of Zoning Appeals. You turn to page 2, the highlighted section, and this again for page 2 of the highlighted section. This board found no hardship. And the pre-existing nonconformity that Attorney Rosati speaks of existed in 2007. The board was fully aware of it. They knew that this map that had been recorded was there and that this lot was an undersized lot, and this lot existed. And they found there was no hardship because of that. You can't not now find a hardship when you have already determined there is none. You can't do it. The map that Attorney Rosati refers to under the Johnson decision is meaningless. It's not a subdivision map. It means nothing in regards to this. He has to prove a legal hardship, a hardship associated with the land. He's right. I'm going to come before you time and time again with variance applications. And I'm going to talk about hardships to the land. I'm going to talk about topography. I'm going to talk about grade. I'm going to talk about funky boundary lines. I'm going to talk about crossing or corner lots. Hardships associated with the real estate. There's no hardship here. They knew in 2007 of this pre-existing non-conforming lot, and they knew of the map of 1914, and it doesn't mean anything. The circumstances have not changed in 10 years. Not a thing. He hasn't proven his hardship. He hasn't proven a change in circumstance, and he has proven a merger of these two lots by the way they have been used together. So, ladies and gentlemen, I would suggest you have a merge, you have one lot. Board found, they knew this wasn't a building lot. They knew that. Board already made that finding, that the owners knew this wasn't a building lot. They could have very easily gone down to the assessor's office, argued that, paid more taxes. They didn't want to do that, because who wants to pay more taxes to get something down the road? So they were more than happy to take vacant land, no building lot. And now they're coming here going, oh, no. It's a building lot. It says so on a map from 1914. Map from 1914 is meaningless. Doesn't mean a thing. Johnson says that. That's the Johnson case I gave you last month. They have to prove the legal hardship. And it's not the nonconformity as a result of a map that has no bearing on whether or not a subdivision exists today. What happened in 2007 is exactly the same today. This board, your board, has already determined there is no hardship for a frontage reduction. Mr. Rosati tells you one of the differences is that there were two applications. No, there wasn't. There was only one application for lot 700. Only one. Only asked for one variance, frontage. That's it. The fact that there was another application has no bearing on a changed circumstances. Now I'm just bringing in one application. There's been a merger. There's no change. There's no hardship. 0 for 3. You have no choice but to deny this. Mr. Chairman, I appreciate your time. I'm happy to answer any questions that any members may have.
Thank you. Any questions for Mr. Proto? Hearing none, thank you very much.
Thank you.
Okay. Okay, do we have a motion to close?
Testimony from the public?
Pardon? Oh, yeah, I forgot about that, sorry. Would anybody like to speak in favor of this petition?
Seems every time that aisle gets longer. Walter P. Rimkunis, 425 Second Avenue. I don't know what the hassle is. 50 by 100 lot, out in Lordship. After 1950s, after the war, became a standard. If you're going to knock it down, you got to knock down about a third of Lordship. 2nd, 3rd, 4th, 5th, and 6th Avenue are on lots 50 by 100. Just because this one was squeezed in there, cut 2 into 1, is no reason why it shouldn't be allowed for a building lot. That's my opinion. Are you going to knock all the other houses down because we're not compliance with this? I think he should get it. Thank you.
Thank you. Would anybody else like to speak in favor of this petition? Hearing none. Would anybody like to speak against the petition? Hearing none. I have a motion to close?
Excuse me, I think I have the right to rebut.
Okay. I'm sorry.
And I apologize because I'm just going to be repeating myself. Again, Attorney Robert Rosati for the applicant. In response to Mr. Proto, there's no clear intent to merge, and again, that's what the case law says you need where there's no merger regulation. A garage that may have been over the property line by a few feet, a driveway a few inches, that's not clear intent. If we were talking about the house being built on the dividing line, I would agree with Attorney Proto, like other houses where people chose to merge and build that way. But in error, having that issue, there's no clear intent, and the deceased owners are not here to tell us. So that ends that argument. And Attorney Proto gave examples of other legal hardships, but the enactment of the zoning regulations after this pre-existing non-conforming lot was created on the land records is a valid legal hardship, and that hardship wasn't found the last time because of all the evidence and the circumstances that were lacking that we have changed and we have shown here tonight. So for all those reasons, there's no merger. You have the right to hear the second application, and there definitely is a legal hardship that you can find. Thank you.
Thank you. Anyone else? Motion to close now. Okay. First by Mr. DeCilio, second by Ms. Young. Moving right along. Mr. DeCilio, would you like to take petition number 2 off the table?
Petition number 2, 70-80 Hathaway Drive, petition of Wag Pants LLC, seeking a waiver of section 3.18 to construct an 8-foot fence in the rear setback for a dog kennel in an MA district. Hardship: site abuts a swamp where deer and other wildlife abound, and the need to separate the dogs in a play area from the wildlife.
Good evening, Ms. Young, Madam Secretary, Mr. Chairman, members of the board, and Mr. Hibansky. My name is Barry Knott. I'm a lawyer with the firm of Knott, Dunn with offices at 1656 Main Street in Stratford. I'm here this evening on behalf of Wag Pants LLC and Wag Pants Central LLC. Angela Pantalone, sole member of which sits behind me in the first row. She lives at 20 Pine Ridge Road, Woodbridge, Connecticut. And at this time, I'd like to submit the certificates of mailing and make reference to a folder of exhibits which I've just handed to each of you, to which I'll be making reference during the course of my presentation. The first 9 of which are photographs of this property. Exhibit 1 is a photo of the front of 70-80 Hathaway Drive, taken from the street. This is the home of Wag Central Indoor Dog Park, about which we will be speaking in greater detail shortly. Exhibit 2 is another photo of 70-80 Hathaway Drive. This building, if you look at it from the street, is a duplex light industrial building. 70 is on the right-hand side as you face it, 80 is on the left-hand side. So picture a duplex house. This is a duplex light industrial building. However, the whole inside is one space. There are not 2 separate spaces inside the building, but it's a wide building. That's why it took 2 photographs to get the whole front of the building. Exhibit 3 is the photo of the building next door to the right as you face the building. As you can see, this is another light industrial building. Exhibit 4 is a photo of the building to the left as you face our building, another light industrial building. Exhibit 5 is a photo of the SNET facility directly across the street from our property. As you can see, that is a large light industrial building surrounded by a large parking lot. Exhibit 6 is a photo of the back of our building taken from the property to the right of our building as you face it from the street. And where that area of concrete is, behind the building where that little car is parked, that is the approximate area where the outdoor play area is going to be located, which Angela will talk about in a minute. And it is that area where we are seeking to have enclosed by an 8-foot high fence. And we'll get into the reason for that in more detail in a minute. But that's the approximate area we're talking about, that white concrete area where the car is located. And Exhibit 7 is a photo taken from the other side of the same area. Exhibit 8 is a photo, I mentioned in my application the swamp behind this property. It's a swamp and it's a wetland. And it is a huge swampy wetland. And it is part of the Pepsi bottling company that is located immediately behind our property, which is on a huge site. I'll show you in a minute. But the trees that you see just beyond the edge of our property line are sitting in wetlands. And you can also see that the elevation of that property to the rear of us, where that wetlands is located, is a few feet lower in elevation than our property line is. Our property was originally filled in to reach a higher elevation. Exhibit 9 is a view of the Pepsi bottling company that you can see in the distance. This is located behind our property, and that's what's back there, the Pepsi bottling company. If you look on Exhibit 10, you'll get a better perspective of these 2 parcels. The 2 properties that are the subject of, that are owned by my client, I've highlighted in yellow on Exhibit 10. And you can see the bottling group, a huge 12-acre parcel behind our property. That's where that substantial wetland swamp area is located that were in those last 2 photos. And the large area across the street from our property, as you can see, is the SNET building that I showed you. The purpose of this exhibit is to show you that the property that my client owns is extremely isolated with respect to neighboring properties, except that to the rear of the site, the Pepsi bottling works, and across the street, the SNET facility, there are no residences in this particular area of town which would be affected by this application. Exhibit 11 is an A2 survey of the premises at 70, 80, and 100 Hathaway Drive. The reason why 100 is shown on this survey is because 100 was owned by the same people that owned 70 and 80 at the time we purchased 70 and 80. And I've highlighted the property that was purchased by my client, which is 70, 80 to the right there, highlighted in yellow. And I've also highlighted a hatched area that runs across the eastern side of 100 Hathaway. That is a 15-foot wide easement that we have across that property next door that allows us to get to the back of our property and be able to gain access to the rear of that property in the rear. Exhibit 12 is another version of the A2 survey, and this version does not show the hatched area representing that 15-foot easement, but does show 4 parking spaces to the rear of the building that can be accessed by virtue of that 15-foot easement area, as well as a proposed fenced-in area to the right rear of 7080 Hathaway Drive, which will be used for the outdoor dog play area. So you can see that gray hatched area to the right of those 4 parking spaces behind the building is the area of the outdoor dog play area, which we want to surround with an 8-foot high fence. And because this area is located in our rear setback, an 8-foot fence violates section 3.18 of the zoning regulations, and that's the reason why we're seeking this variance, because you're only allowed a 6-foot high fence, and we're asking for an 8-foot high fence. But it's in that gray hatched area where that 8-foot high fence would go. Now, as you can see from this Exhibit 12, the property is 32,750 square feet. It has 200 feet of frontage on Hathaway Drive, 157 feet deep along the easterly boundary with 40 Hathaway Drive, 171 feet along the westerly boundary of 100 Hathaway Drive, is 201 feet across the rear, and the building itself is approximately 15,000 square feet in size. There are 30 parking spaces on site, which are the required number of parking spaces. Exhibit 13 represents the interior floor plan of our proposed facility. And this proposed facility is an indoor dog park. Angela is going to explain to you in a minute what an indoor dog park is and what the concept is for her business plan down there. But this is the layout that is anticipated. It includes offices, grooming stations, kennel areas, a kitchen, sleeping area, and an indoor swimming pool, as well as offices for, yeah. Yeah. I hope you're not suggesting that the hot air is coming from this microphone. Oh, thank you. No. Not after Rosati and Proto were up here already. Okay. Exhibit 14 is the approval letter that we received from the Stratford Zoning Commission authorizing use of the property as an indoor dog park. We received that in June of 2016. Once we received that approval, my client purchased the property on September 1st, 2016, and has been proceeding full steam ahead to convert the premises to an indoor dog park with renovations to the building totaling approximately $2 million in out-of-pocket expenses by her, in addition to the cost of the building itself. Now, the full-service hours of operations will be between 6:30 a.m. and 8 p.m. In the event of a dog staying overnight for kennel or boarding purposes, at least one employee will stay on premises for that overnight shift. Otherwise, it is anticipated that between 6 and 8 employees will work on site during regular hours of operation. These include a manager, a receptionist, 3 park rangers, who are people who train, supervise, and control the dogs, a dog groomer, and possibly a veterinarian who will see patients by appointment. I want to discuss Jay's administrative comments and the hardship. In his comments, Jay points out that the application is for a parcel located in light industrial district and that the surrounding uses include mechanical services, linen services, auto parts supply, multiple shipping and receiving warehouse, incidental offices, and other light industrial uses. He also confirms that my client received special case approval on June 29, 2016 to establish the indoor dog park, and that the outdoor play area, which is the subject of this application, was incorporated in the approval that we received from the zoning commission. So we're not asking for something new here. We're just asking that the fence be higher. Jay also points out that the granting of this variance would likely have minimal impact on the surrounding uses in the neighborhood. Now, the hardship claims in support of this application is the site abuts a swamp and other substantial wetlands where deer and other wildlife abound. And the applicant needs to be able to segregate her dogs in her play area from this wildlife. Unfortunately, or fortunately as the case may be, there are certain species of dogs which are capable of scaling a 6-foot-high fence, and which would be at risk from escaping the fenced-in play area under certain circumstances, or if provoked by other animals or neighboring wildlife. While the proximity of deer and other wildlife in the swamp and wetland areas to the rear of our property applies to all property on the north side of Hathaway Drive, because that wetland area is behind the whole street. It is only my client which is adversely affected by this situation, because it is only my client which has an outdoor play area for dogs, large and small, in close proximity to this swamp and wetland area. According to law, the hardship applies only to my client, although the condition, the swamp condition, theoretically affects all property on the north side of the street. This condition is not a hardship for the other property owners, because they're running machine shops down there. It is a hardship for my client because she's putting in an outdoor play area, and some of the dogs will be able to jump over a 6-foot-high fence. I had a poodle that we rescued about 15 years ago, and I swear the dog could jump up and reach that chandelier. We called him a jumping dog. I think he came from the circus. Anyway, at this time I want to introduce Angela Pantalone. She's the managing member of WAG Central LLC, which is the owner and operator respectively of this property, who will be managing the facility, and Angela will explain her concepts to you in detail, show you the turf that's going to be on the ground outside in the back so you'll understand what's going to go there. Angela? This is the turf.
Hi, I'm Angela Pantalone. I live at 20 Pine Ridge Road in Woodbridge, Connecticut. And as Attorney Knott mentioned, I purchased the property back in September of last year. And I am working hard and getting near to the end of my project of transforming an old NCON building into a dog heaven. The concept is that dogs are experiencing they're really part of our families. They're like the new kids. So at WAG Central, we really hope to embrace that and let dogs be dogs. We're going to set them up not to fail. And by setting dogs up not to fail, we give them lots of opportunities to have fun, to swim, to exercise. We'll have dog training. We'll be able to socialize dogs in our cafe between dogs and humans. We have a retail section really emphasizing a lot of the things that we are using at WAG Central in our training area and our indoor dog park so that people can later on purchase them and bring them home. Our swimming pool is a great asset to an area here where we are a waterfront community. We have the beach here. A lot of dogs swim. We can help dogs learn how to swim. We can show people how to use life preservers. Our pool is going to be big enough to house a paddle board and a boat so that dogs can be trained to sit inside and join their owners when they go out in the water. We have lots of flexible space within the area to segregate dogs, and lots of kennel rooms for different sizes of dogs and for different dogs and how they like to rest at night. 45% of dogs sleep with their owners at night, so we have a community room where dogs can sleep together with a TV, kind of like a sleepover room. The room will have some bunk beds, but we also have kennels that are glass enclosures and stainless steel enclosures. within the rooms based on different sizes to house dogs separately at night. We have a speaker system so that dogs can listen to music or NPR if that helps them fall asleep and feel rested being away from their families. And we also have a state-of-the-art heating, air conditioning, and ventilation system, which includes a UV lighting called pet therapy, which will not let any kind of disease remediate or move between the rooms. We have dog-safe flooring. It's padded, it's floored in a way that dogs cannot slip. It's an epoxy flooring, so it's literally like a swimming pool itself, so it's very easy to clean. If a dog urinates or it gets sick on the floor, it's easily cleaned up. We have a wet-dry vacuum system called Aqua Air. I have a specialist coming up from Houston who did part of the installation. He'll continue that. It's an easy way to clean the floor without using mops to spread waste and germs around the facility. We're able to spray our cleaning product mixed with water right on the floor and then suck up into the vacuum that takes it right out to the sewer. So it's really clean, state-of-the-art. I've basically traveled the United States going to different dog care facilities, going to different expos in this industry and bringing it all here to Stratford. So it really should be state-of-the-art. Now that I'm nearing the end of the project, we're getting to the part where we're putting the outdoor turf on. That turf that you just saw cannot house a flea or a tick. It won't be able to live inside that. The dogs won't be able to dig that up, which you know there's a nature of dogs digging things up all the time. These pieces, they're actually a lot bigger, but they'll fit in like a puzzle. So within the fencing, we'll put the turf will be installed, and we can hose it down, and it's also designed in a way that we can pull it up to later on clean the actual cement underneath if it starts to smell from the urine that will go into the ground from there. So it's complicated, but it's been a really exciting experience putting all of this together. I'm anxious to finish the project, but I am concerned, of course, like I've mentioned, about the health and safety of the animals all the way through. And now that we're at this section, I myself have a little Jack Russell Terrier. She's 15 pounds, but she likes to catch a Frisbee, and we clocked her at 7 feet in the air. So some of these things, when we're letting dogs be dogs, letting dogs enjoy themselves, and letting dogs not fail, we've got to be able to let them run around and be who they are. And within this back area, knowing that there's an 8-foot fence, it'll really help protect the dogs and keep them safe.
I mean, it's really an amazing facility. I've been down there a number of times to watch the construction. He's putting approximately $2.75 million into this facility. And quite frankly, I've been asking, I was thinking of asking her to see if she could fit a cage in the kennel area large enough to take me, because it sounds like it's going to be pretty nice down there. She hasn't committed to that yet, though. But anyway, that's it. Thank you very much.
Thank you. Any questions?
Yeah, I just have a couple of questions, Attorney Knott. Just so I'm clear, your Exhibit 12, the only area that you're going to require an 8-foot fence is the perimeter of that shaded area directly behind the building.
That's right.
Do you know what type of fence you're going to put up? Is it going to be PVC? Is it going to be wood, stockade? And will it have a gate that will exit that play area to the back of the property?
Yes, I've been working along with the fire marshal to properly design the fence, so it definitely is easy to egress. The foot is PVC vinyl, pretty white, pretty boring, but we'll hold all of this in, so it'll be added close enough to the ground to hold everything in, and I think it's a great choice.
Okay, thank you.
Any more questions? Ms. Young?
My question perhaps is to your client. To understand the area that you have defined for the outdoor area, instead of bringing it all the way to the property line, were you trying to maintain circulation around it? Is that why it's confined to the space that you have proposed?
Yeah, I think it's important that we're still able to get a car behind there, be able to clear snow, even when we have a lot of snow and you're wondering where you're pushing it, just really trying to be aware of all of that. I've had a lot of great help, not only Attorney Knott, but architects and other workers saying, okay, you need this is what you need, and help from the building officials as well. So it's really been thoughtfully designed.
And can I ask, I'm not sure who wants to respond, why 8? Why not some other number? How did you arrive at 8 as your proposed height?
Actually, it's an industry, I wouldn't say it's an industry standard, but it's a good recommendation based on the fact that there are breeds that can jump that high. Pit bulls, I even mentioned Jack Russells, Barry had the poodle, huskies, malamutes, a lot of dogs that you would probably see around this community, even labs, can have the capacity to jump that high.
So you're comfortable that 8 should meet your needs to keep the animal safe?
Yes.
And thank you again for bringing your business to Stratford.
Thank you. I'm excited to be here.
Any other questions? Okay. Anybody like to speak in favor of this petition? Thank you, Mr. Knott. Hearing none, anybody like to speak against this petition? Hearing none, motion to close. Mr. Hoydick, Ms. Young, thank you very much. Okay, Mr. Hoydick, would you like to take petition number 3?
Yes, sir, Mr. Chairman. Item 3, 475 Hawley Lane, petition of Red Buff Rita Incorporated to appeal the decision of the Planning and Zoning Administrator regarding the certification of zoning compliance for a liquor permit after the license has expired.
Good evening, everyone. My name is Jonathan Klein. I'm an attorney with an office at 1445 Capitol Avenue in Bridgeport, here on behalf of the appellant, Red Buff Rita, Inc. I have a few exhibits, and rather than hand them out piecemeal, I have copies, more than enough copies for everyone, including Attorney Florek. And if there are 3 of them. One is a letter, which I'll refer to. Another one is a copy of a liquor license status from the website of the Department of Consumer Protection, and the other is just the relevant excerpts from the zoning regulations. While that's being distributed, let me, if I may, explain the procedural history of how we got here. Back in October of 2015, a letter was written to the then Planning and Zoning Administrator, Gary Lawrenson, by Gus Curcio Sr., who is the president of Red Buff Rita, Inc., in which it had come to his attention that when a liquor permit application was filed for this particular premises at 475 Hawley Lane, Suite B, by Jean, I may be mispronouncing the name, but Jean F. Dong, doing business as Harvest House, that Mr. Lawrenson had signed off on the zoning compliance portion of the liquor permit application, stating that to the Liquor Control Commission that the premises was in compliance with the zoning laws of this town. However, as was pointed out in the letter, Mr. Lawrenson had consistently stated in other situations that if a liquor permit of any kind expires, and the applicant would have to start the entire process over by seeking the approval of the zoning commission. The first exhibit is a copy of that October 16th, 2015 letter from Mr. Curcio to Gary Lawrenson. And it pointed out that the liquor permit for that location had expired on May 30th, 2015. There was a prior restaurant there known as the Asian Bistro. And the second exhibit you have is the printout from the Department of Consumer Protection that shows you that, in fact, that restaurant liquor permit expired on May 30th, 2015. The application of the Harvest House came along several months after that, and Mr. Lawrenson signed off on their application on August 12th, 2015, almost 3 months later. And what Mr. Curcio asked in that October 16th, 2015 letter was asking that Mr. Lawrenson withdraw his approval signature on the liquor permit application and require the applicant to go through the same application process that anyone else has to go through, which is to apply to the Zoning Commission for approval of that location. Mr. Lawrenson did not do that. Then, November 10th, 2015, I faxed a letter to Mr. Lawrenson following up on this. Actually, prior to the November 10th, 2015 letter, which is part of the appeal packet that was filed here. I had spoken to Mr. Lawrenson myself the day before on November 9th, 2015, to verify whether, in fact, what my client was stating in that letter is correct, that it was a long-standing policy of the zoning department in this town to require a new application to the Zoning Commission if a prior liquor permit had expired for that location. He verified, yes, that is the policy. So what I asked in this letter, in much more detail than in the Mr. Curcio's letter, was for Mr. Lawrenson to comply with that policy and to pointing out that obviously the reason for that policy is because that's what the law requires. And I'll get more into the detail of the law in a moment, but again, giving you the procedural history of this thing, which is a little bit complex. Mr. Lawrenson basically ignored this letter, and he did not, and then when he did not rescind his sign-off on the zoning compliance portion of the liquor permit application, we appealed this. We filed an appeal to this board, the Board of Zoning Appeals, appealing Mr. Lawrenson's refusal to rescind that signature. But what Mr. Lawrenson did was he refused to put it on your agenda. So depriving us of the right to be heard by you, we filed an action in the Superior Court called a mandamus action, the goal of which was simply to require Mr. Lawrenson to submit this to the Board of Zoning Appeals, put it on your agenda so that you could hear the appeal of his refusal to rescind his sign-off, and to require the Zoning Board of Appeals to conduct a hearing. That languished in the court system for a while, and a couple of months ago, shortly before it was scheduled, the case was scheduled to be tried, Attorney Florek, that is John Florek, agreed that, you know what, you have the right to be heard by the Zoning Board of Appeals. So we resolved that by agreeing to have Mr. Hibansky, who's now the current Planning and Zoning Administrator, put this on your agenda so that we could be heard. And once he did that, the case was in the court was withdrawn. So that's how we got here tonight. So what we're asking now is for the Board of Zoning Appeals to basically just follow the law, which I'll explain in a moment, and simply direct Mr. Hibansky to rescind the sign-off of zoning compliance on the liquor permit application of the Harvest House, and require the Harvest House to do what everyone else has to do to comply with the law, and that is to submit an application under the provisions of Section 15.1 of your zoning regulations for approval of this location. Now, The reason the longstanding policy that Mr. Lawrenson had spoken about complies with the law is this. Section 15.1, what you can't do is simply piggyback on the fact that a prior expired liquor permit had once existed. Because here, where there was a gap of several months, and which is acknowledged in John Florick's memo to the board that was submitted to you on April 24th, the prior approval of this location does not run with the land. It is personal to the liquor permit applicant. And the reason it doesn't run with the land is explained on page 2 of the of my November 10th, 2015 letter. State statute, Connecticut General Statute, Section 8-6, provides that any variance that's granted by a zoning board of appeals shall run with the land and is not personal in nature to the person who applied for the variance. But the approval required by Section 15.1 of your zoning regulations, which is to be issued by the Zoning Commission, is not a variance. The variance, of course, can only be issued by this board, the Board of Zoning Appeals. The application under 15.1 goes to the Zoning Commission. Since it's not a variance, it does not come within the scope of that statute and does not run with the land. Now, outside of the statute, there's case law that establishes that a special permit, or as it's called in the town of Stratford, a special case, the approval of a special case also runs with the land. But the approval that's required by Section 15.1 is not a special case, because Section 15.10 of the regulations provides that only an application, and I'm quoting now, an application for the enlargement, extension, or alteration to any class of permit as defined by Section 15.8 shall be a special case, subject to Section 20.2 of these regulations. End of quote. So it's not a variance, it's not a special case, and for those reasons, the prior approval of this location for Asian Bistro does not run with the land. When that liquor permit terminated on May 30th of 2015, that was the end of the road for a liquor permit at that location, unless and until someone else comes along with a new application. That's what the Harvest House did, but what they're required to do by the law and by the longstanding policy of the Planning and Zoning Administrator, because it complies with the law, is for them to submit an application under 15.1 to the Zoning Commission. It didn't happen here. And basically all we're asking to happen is for the Planning and Zoning Administrator to comply with the law, and for and to have the Harvest House go through the same application process that anyone else would be required to do. I've seen the memo that John Florick submitted to the board, in which he doesn't find anything definitive to tell you that our position is incorrect. What he says is that Section 15.9 of the regulations seems to impliedly indicate that there's an 18-month period during which a subsequent permit may be approved without causing a previous location's approval to lapse. And while I have a great deal of respect for Mr. Florick, he's mistaken in that regard. The failure to obtain, and you have in the excerpts of the regulations that I submitted to you, Section 15.9. And what Section 15.9 says, and it's a short sentence, I'll read it, quote from it: the approval of location for any type of permit, meaning a liquor permit, under Section 15, is conditional upon the subsequent issuance of a permit for the location by the State Liquor Control Commission. Failure to obtain such permit within 18 months from the date of approval shall restore the location to its former status. That is, failure to obtain a permit within 18 months from the date of approval, restoring it to former status, doesn't really have any practical application in this situation, because the former status of the location, which is the previous zoning commission approval of the Asian Bistro's application, again, does not run with the land. The previous liquor permit has expired, so the concept of former status becomes meaningless to the new owner, or in this case, the new tenant of that location. They're basically coming in with a blank slate. They have to submit an application for a permit. That application requires an application to the zoning commission under section 15.1 for approval, and they may very well give approval in this case. But we've got to follow the law, and that's not what happened here. What we're asking, the relief we're asking for here is for this board to direct the Planning and Zoning Administrator, Mr. Urbanski, to rescind Gary Lawrenson's sign-off of zoning compliance and submit that to the Liquor Control Commission, and then to entertain an application under 15.1, and to have the Zoning Commission then entertain an application of the Harvest House under section 15.1. Just in case there's any doubt, because Mr. Floric in his memo seems to have some doubt as to whether this was a long-standing policy of the zoning department to require a new applicant after a prior permit had expired to go through the process. I have with me Mr. Dale Donofrio, who works for Mr. Curcio. If you would stand up here, Dale, he can attest to the fact that he personally has had on more than one occasion had dealings with the zoning department over the years for liquor permit applications for various locations, and this is what he's been told by Gary Lawrenson, and that has been the practice. Mr. Donofrio, can you tell us if you've ever discussed with Gary Lawrenson what their practice was when someone comes along after the expiration of a liquor permit and applies or seeks his sign-off of zoning compliance on their liquor permit application?
Yes, I was told on a couple different occasions that a full zoning application had to be submitted to the board and approved before they would sign off on it.
And that's been your experience in submitting applications?
Yes.
And again, that's not surprising to hear, because what we maintain, Mr. Lawrenson has said, and what he said to me as well, is that's the zoning department's policies, because that's what the law requires. It's very simple. That's what the law requires. So, if you have questions, I'd be happy to entertain them.
Any questions?
Yes.
Yes, Attorney Klein, I have a question. Does Harvest House currently have a liquor permit?
Yes. And they had that in part because of Mr. Lawrenson's...
And what is your client's interest in Harvest House or in this liquor permit?
You know, frankly, I don't know, but the answer really is it doesn't matter. Because the law is what matters. Compliance with the law is what matters.
I get it. But let me ask you a question.
Yes.
And I'm not asking you the law. If you mailed in your fee for your law license, and it got lost in the mail, and your law license lapsed, do you think you should have to sit the bar test again?
No, but that's not a...
I know. I'm just asking you a question. I just don't get...
It's an apple and oranges comparison.
I understand. But to me, it seems... I just don't understand why we're here.
Well, you have somebody different. I mean, to make that an apples-to-apples comparison, it's like if my law license lapsed because they didn't file something, didn't pay a fee, and then someone else comes along and wants to apply to be admitted to the bar based on my license, it doesn't work.
So you're saying there's a change of ownership
Yes.
during this Harvest House? And,
Harvest House is a completely different person than the Asian Bistro was.
oh, I see. So
They have nothing to do with each other.
is there a requirement in the law, since you're the expert, on transferring a business? Does the license transfer with it, or does that re-trigger
No.
a public hearing, or not a public hearing, a brand-new application?
The liquor permit's not transferable.
Okay. Got it. Thank you.
Any other questions, Mr. Young?
Even one that had not expired. Liquor permits are not transferable.
I have a question for Mr. Bansky. Mr. John Floric, in his memorandum received April 24th, asked about the policy that Mr. Lawrence and the correspondence from November 2015 relates to. I'm curious, what is the current policy, if you're aware of any current policy?
To be honest, we haven't had to address it. We haven't had any instances like this since I started in February 8th, 2016. So in an instance like this, I probably would consult with the town attorney, get their opinion on it, and to find out exactly what the state laws are and what's required of myself as well as the applicant.
Sounds like good advice. I think I'll take it too. I guess I am grateful for the chronology of events as you outlined them, because if we're talking about 2015, as we sit here in 2017, I was
Yes.
curious, why hadn't the appeal period been exhausted from your client's perspective? And I guess this was a mutual decision by the town of Stratford and your client to eliminate the mandamus action.
Right, just,
we would
okay,
be
have
allowed
your
you to
day.
come forward
Right.
now.
Right, and I appreciate that.
To provide a little context on the mandamus action, it was initiated normally in a zoning appeal. The adjacent property owners and property owners with 100 feet are entitled to appeal. They are aggrieved by a decision of the zoning commission or you guys. With liquor permits, any property owner in the municipality can appeal a decision regarding a liquor permit.
That's very
That's right.
helpful.
And I appreciate Attorney Flork mentioning that, because I had forgotten to mention. Right, it's very well established under the case law that any taxpayer in the town has legal standing to raise the issue. Yes. Thank you.
Now, would you like me to speak to the issues of longstanding policy?
If you have knowledge, thank you.
My knowledge and experience is briefer than Attorney Klein's, but usually if somebody appeals the decision of a town board or authority and says, why are you doing X, Y, and Z, and we point to a long-standing policy, that argument doesn't carry much water. To turn the current appeal on its head, imagine if the current operator of that restaurant, imagine if they were informed by Gary Lawrenston that they had to go back to the zoning commission to once again get approved for a liquor license. We would probably be here because they would say, well, you can't hang your hat on a long-standing policy and procedure. You need to show me something in the zoning regulations that tells me I have to come back to the zoning commission to get my liquor location permit reapproved.
And when what I'm saying, just if I'm repeating myself, I'm sorry, I just want to make clear. Even if we take this long-standing policy of the zoning department out of the equation completely, the result is the same. Because under your zoning regulations, the new applicant, in this case the Harvest House, has to submit an application to the zoning commission for approval of this premises for a liquor permit.
To that end, if I may, is that an accurate assessment by the town attorney's office or Mr. Hibansky that if this board does not uphold this request, and we deny this request, and the liquor permit is maintained, that there's still going to be an application before the zoning commission in the opinion of the town of Stratford?
That the current operator of the restaurant would have to come before the zoning commission for liquor location approval?
Correct.
I mean, I don't believe so.
I didn't think so.
Attorney Klein could appeal your decision to the Superior Court.
Sure.
And that's his prerogative. First of all, I mean, he's right. Variances in special cases, as we call them in Stratford, do run with the land. I don't know that this restaurant was never approved as a special case. I know that there have a lot of liquor locations must be approved as a special case. Ice cream shops in this town have to be approved as a special case. I quite frankly don't know that this particular restaurant was never approved as a special case. I just haven't had the opportunity to do that research sitting here in the pit.
So to answer my question, which I think you did, but I want to make sure I understood, there's no position of the town of Stratford that there's a need for the current restaurant to come back before the zoning commission. Assuming we do not grant this relief, they can continue to operate as they have been. Only if this attorney takes an appeal of our decision, would there be a need to go back potentially before the zoning commission?
The current opinion of the town attorney's office is that they do not need to come to the zoning commission for a liquor location permit. However, if Attorney Klein appeals to the Superior Court on behalf of his client and a judge orders us and finds the other way, then you will likely see the applicant back before the zoning commission. If that court saw this issue Attorney Klein's way.
Thank you for that clarification.
Okay, any more questions? Hearing none?
May I just say one more thing? I believe what would happen here, I'm not 100% certain, but I believe what would happen here is if you were to grant this appeal, and which then sets into motion the rescission of the zoning compliance sign-off on their liquor permit application, and that's transmitted, of course, to the liquor control people. I don't believe liquor control would immediately revoke the permit. I think what they would probably do is tell the Harvest House, go and get your approval for the zoning commission, and you can continue to operate, at least provisionally. I think that's what would happen. I can't tell you with 100% certainty.
Okay, any more questions? Thank you.
Thank you.
Would anybody like to speak in favor of this petition? Would anybody like to speak against the petition? Hearing none, do we have a motion to close? Ms. Young? Mr. Vars? Okay. Now I need a motion to close the public hearing. Mr. DeCilio, Mr. Hoydick, and now we'll go to the administrative session. Okay. Right here, do we have a motion to take petition number 1 off the table again? Mr. DeCilio? Mr. Hoydick, second. Mr. DeCilio. Any discussion?
Yes, Mr. Chairman. This is a very interesting appeal, not unlike many we've heard on my tenure on the board relative to pre-existing lots throughout Stratford. I made a bunch of notes, and I'm going to bore you for a minute because I took a lot of time on this to make an argument in favor of approving this application, and then I'll ask my fellow board members if they concur with my logic. Just to be redundant, the applicant's appeal, he argues that they own an existing 50 by 150 lot, that it predates zoning, that currently requires 60 feet, and that the current lot has only 50 feet. The applicant further claims that the property is pre-existing non-conforming lot created in 1911 and therefore has a hardship. Furthermore, the applicant states that the lot in no other way is non-conforming and that the proposal meets all side yard, front yard, rear yard coverage and lot area requirements. I took a look at Mr. Hibansky's planning review comments and his additional comments, and he states that the petitioner is seeking the variance, and he further states that because the lot has been verified as pre-existing and predating zoning, the unusual size of the lot appears to satisfy the hardship criteria. And then in his second letter, he amends his comments reaffirming this. Now, the opposition argument gave us two pieces of case law, Laurel Beach Association versus Milford, and also, what was the second one? Stratford, Johnson versus ZBA Stratford. And I read both of those. I feel like I went to at least a day of law school. The Laurel Beach case had to do with a barn being converted into some residential apartments, and had to do with pre-existing units that were non-conforming. And the question before this board becomes, is the current application substantially the same? We've heard this several times by both attorneys. The original application, in spite of what the opposition attorney says, was heard in conjunction with the adjacent property. So they were presented together. I actually spent time reviewing that file, or those files, I should say. And they were denied together. And we had one of the denial letters presented to us, but I was actually able to dig the other denial letter out today out of the file. So that proved they were together. This application is substantially different because, at least in my opinion, because it has only a single variance request. It doesn't have a coverage, doesn't have side yard, front yard, rear yard. I think the other one had 2 or 3 different requests. So it was a little bit, and it was different. In the Johnson versus ZBA case, it was actually a little bit different, and that was fascinating because even though it was presented to us by Attorney Proto, it went one way for him and one way against him. And one way for him, it said that the lot is not protected, which is why we're here. And the other way, it said that it's absolutely clear that they're not merged. It says, quote, moreover, the Stratford zoning regulations do not require merger explicitly and do not support an inference that the merger was intended. So, and then Attorney Rosati tonight added to that the Connecticut land use practice, which I'm not sure how much weight that would carry relative to law, but it's their practice, confirms this. Lastly, and really the deciding factor for me to support this application was the character of the neighborhood. And what I did was, I walked by the lot today, by the way. It's a beautiful street. What I did was, and if I can find it,
You're not going to, excuse me, introduce new information that wasn't on the record.
No, this was submitted as an exhibit. Let me just find it. One moment. Thank you. If I could dig through this pile, we have a lot of stuff here. And I'm going to reference conformity to the neighborhood. This is a map, exhibit number 9, submitted by Attorney Rosati. For the members of the commission, I'm just going to show it to you. I disagree with both Mr. Rosati and Mr. Proto on what is the neighborhood. Mr. Proto said the neighborhood was this big. Mr. Rosati said the neighborhood was this big. So I used my own logic, and I highlighted 3 blocks either side of this lot, from the water up to Crown Street. And I counted the non-conforming lots and the conforming lots to the gentleman who spoke in favor of it, and I was shocked. 39%, or 72 of the properties, are non-conforming frontage, and 113 are conforming frontage. That's a 6-to-4 ratio. I thought for sure it was going to be more like 9-to-1. So what this tells me is that this is in character with lordship and the neighborhood. So those are my notes, and before I consider a motion, I want to hear what my fellow members think about that.
Okay, Mr. Hoyter.
Yeah, I think Mr. DeCilio has some valid points. The only issue I have is overturning a prior zoning commission's decision. And is there enough new evidence in terms of a change in the position of the property or something different that's enough to make us reconsider it to overrule a previous board's decision. And I personally don't think there's enough substance to do that. And I do agree that there are many parcels in the area, Mr. Rakunas, and as stated by Mr. DeCilio. But that's something, in my mind, that's a little separate from the issue of overturning a decision that was made in 2007. And I personally am not convinced. That's basically it.
Any other discussion? Ms. Young?
I am grateful for all the time and energy spent not only by the applicant but by the neighbor's attorney in opposition, as well as Mr. Hibansky and Attorney Florick, in giving us a lot of background on difficult case law and understanding from my perspective of merger. So again, I'm grateful to all parties concerned. I personally was convinced that this board may review this application, that the applicant's attorney listed, I stopped writing after the sixth reason of why conditions had changed significantly since 2007. So I'm personally convinced that we are entitled and authorized to look at the merits of this application. That being said, I am stuck, as I always am, with the hardship question. What is unique about the circumstances that deserve a variance of the zoning regulations? That's a test we put all of our applicants through. And self-created hardship often comes into the conversation. The property has been vacant for decades, if not a century, depending on how you count. And obviously there's a desire, I assume a financial desire, to develop it for a single-family home. So I wrestle with the question of, has adequate hardship been proven to allow the regulations to be modified? In my opinion, that's where we need to focus our attention. And I appreciate Mr. DeCilio's analysis and homework, self-created homework that he did, that we can all benefit from. And I guess I would ask if in his analysis that brought him to the conclusion that he might be prepared to make a motion to approve, if he is considering any motion that would include conditions associated with it, such as those offered by the applicant's attorney, that we received the 3-item memo tonight of how to mitigate the concerns of the neighbor at 150 Margarita Lawn, along with the mitigation suggestions offered by Mr. Hibansky in his April 17th memorandum. It may actually have been his first memorandum, where he talks about the board may choose to require planting treatments in the front of the home, shade tree in the front and rear of the property be included as conditions of approval, which I think then may speak to the neighbor who didn't come tonight but was heard in the form of his memo. I think he was to the south side of the property, Tom O'Connor. So that's where I'm at.
Mr. Tavares.
I too had pretty much of a difficulty in rendering a decision, a palpable decision. From what I can see, the applicant made every effort to comply with what some of the neighbors were saying, as far as the garage and as far as not having windows on the other side. What I was looking for is, as long as the person didn't just Xerox a copy of what happened 10 years ago and resubmit it. So there were some differences, and I think that the applicant made every effort to comply with getting these variances, and I think that it should be approved.
Okay, do we have a motion?
I'd like to make a motion to approve Lot 700 Margarita Lawn for the conditions I stated earlier. The hardship exists, the application is substantially different, and the lot is in character with the neighborhood. I'd like to also condition that approval on the following 3 items: that the garage shall be located with a 10-foot side yard set. Wait a minute, let me see. This is Attorney Rosati's. Let me read these before I just read them into the record. Okay, the garage shall be located with a 10-foot side yard setback on the side facing 150 Margarita Lawn. There shall be no windows on the side of the house facing 150 Margarita Lawn, and there shall be landscape screening provided along with the common boundary between lots 700 and 150 Margarita Lawn.
Do I have a second? No second on the motion. Ms. Young?
I did not second the motion, no.
Oh, I can see that far. Anybody like to second Mr. DeCilio's motion? I
There
don't
being no second, I withdraw my motion.
Okay. Do we have a motion to deny this application?
I will make a motion to deny the application with the explanation that I gave just a minute ago, that I don't personally believe that there's enough change in the original, from the original application to warrant an overturning of the 2007 board's denial of this application.
Okay, we have a motion to deny. Do we have a second? Wait, we're batting 1,000.
I wanted to make a motion to approve.
You want to make, okay.
Do it again.
Okay, since we have no second on the motion
I
to,
will withdraw my motion.
okay, do we have a motion to approve?
Motion to approve.
Do we have a second? Okay, all those in favor?
Can we ask for more clarification on your motion to approve? Again, I was asking Mr. DeCilio, when he made his motion, if it would include additional conditions, such as the 3-pronged item that the applicant's attorney offered for mitigation for the property owner at 150 Margarita Lawn, and I asked him if it would also include the mitigation suggested by Jay Habansky in his memo about landscaping of shade trees in the front and the rear of the property, which didn't make it into Mr. DeCilio's motion. And so I wonder, what form does your motion take? And what is the hardship that you are referencing as a rationale for granting it?
I would accept if those motions were put in. I would accept if that was included. The garage, the setback of the garage, no windows facing 150 Marguerite Lane. And third.
And Mr. Herbansky's suggested mitigation in his, he says, the board may choose to require planting treatments in the front of the home and shade trees in the front and rear of the property.
Yeah. Agree to that.
And what is the hardship you're relying upon?
That the applicant will go from 60 feet to 50.
Mr. Herbansky offered in his memo, so I wondered if you wanted to borrow from his prose, pre-existing non-conforming lot that predates zoning.
Yes.
Okay. We have a second. So we have a motion by Mr. Tavares, a second by Mr. DeCilio. Any more discussion? Okay, all those in favor say aye.
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 And all those against? 3-2. Mm-hmm. Okay.
Was that 3-2 and it fails to get 4 affirmative votes?
Yes. Okay. Mr. DeCilio, would you like to take number 2 off the...
Yes,
Right.
we can take number 2 off the table, 7080 Hathaway Drive.
Okay, do we have a second?
I'll second.
Mr. Hoyt. Any discussion?
I would like to make a motion to approve application 70-80 Hathaway Drive. I'll read it. The petition of Wag Pants LLC seeking a waiver of 3.18 to construct an 8-foot fence in the rear setback of a dog kennel in an MA district. I believe that there probably is enough hardship in terms of safety issue for probably the dogs themselves and any pedestrians that might be around the perimeter of the property, seeing that there is a condition where a dog can't jump a 6-foot fence, and I think that's enough to grant this application.
I'd like
Okay,
to
do we have a second?
second the motion and thank Mr. Hoydick for expanding upon what the applicant offered as their hardship. I think you really nailed it when you said it's the public safety concern for the pedestrians who may be adjacent to the fence who don't want to have a dog jumping out at them.
Okay, thank you.
Okay. Any more discussion? All those in favor? Aye. Okay, 5-0 carries. And Mr. Tavares, we'd like to take number 3 off the table.
Yes, make a motion to take number 3 off the table.
Do we have a second?
Second.
Ms. Young? Okay, any discussion?
I have a question,
Yeah.
just a procedural question. If I do not want to grant this, what is the form that my motion would take since this is an appeal of a decision of the planning administrator? Am I denying the appeal if I don't like it? Is that the wording I'm looking for?
I suppose that's correct, yes.
So I would like to make a motion to deny this appeal. I was persuaded by Attorney John Florick's letter where he said appealing an unwritten policy is nebulous at best, and so I don't think there's any facts on the record that require the decision to be overturned by the planning administrator. Since there's insufficient evidence, in my opinion, to overturn the decision of the planning administrator, my motion is to deny this request.
Okay, we have a motion to deny. Do we have a second?
I'll second it.
Mr. Hoydick, seconds. Any more discussion?
Mr. Urbanski, do you think we've gotten enough on the record to support our decision, or would you ask us to continue talking? Sure, for the department's sake, you don't want this going on for another 3 years.
I just want to check to see if the notes here. No, there are no other comments that I have.
So you think it's sufficient to say we were not persuaded by the evidence offered, if there's a necessity to overturn this?
Sure, I think, you know, an unwritten policy, I think, is enough in my opinion.
Thank you.
Okay. Even though they had a liquor permit there previously, and they want to put another liquor permit. I mean, I don't see the big deal.
I'm not sure what you're asking.
Well, they did have an existing restaurant in there with a full liquor permit, right? Guy let his license expire, right?
Correct.
And they didn't come back in 18 months, but it's still the same thing. They still want to put another restaurant in there. I don't see no big problem. Okay, we have a motion to deny in a second. Okay, all those in favor to deny?
Aye.
Okay, and I'll be against it. 4 to 1. Okay, I guess we're closed now.
Did we have to
We've got
approve
some
any
more work.
minutes?
Huh?
The administrator.
Yeah.
Mr. Chairman, may I make a motion
Yes,
to
sir.
approve the minutes of April 4th, 2017?
Second?
Approval minutes by Mr. DeCilio, second by Ms. Young. All those in favor? Aye. 5-0. Anything else?
I don't think so.
Any other items?
Here.
Okay, oh, okay. Campsite,
No applications.
no applications, okay. Next one is members' concerns or comments? None? Okay. Other items? None?
For me?
Adjournment?
Make a motion.
Yay, okay,
Good
let's
motion.
go.
I'll second that.
That's unanimous.
All in favor?
Okay,
All in
thank you
favor?
very much, guys.
Thank you.
You're welcome.